So, as Michael noted during his remarks, Title I was universally embraced, and it was used almost immediately once the Jobs Act became effective. And what we have seen is that, indeed, there's been a revitalized IPO market. Perhaps not the level of IPO activity that certain congressmen and other commentators had at first predicted when the Jobs Act was being contemplated. But what we have seen is a return to a healthier and more vibrant IPO market. So on this slide, you have some numbers just to give you a sense of who's using the Jobs Act and the extent to which the Jobs Act is getting used. What you'll see is that almost all of the IPOs that have gotten done since the Jobs Act was passed have been by companies that qualify as emerging growth companies. And so the stat that you'll see there is about 80%. That's since enactment of the Jobs Act. If you were to look at just 2013 IPOs, that percentage would be something closer to 95%. So really almost every company that's doing an IPO is now able to and availing itself of the emerging growth company IPO on-ramp provisions. And it is serving its purpose of permitting tech companies, life science, and biotech companies to go public. So if you look at the types of industries where registrants have been most active in terms of IPOs, tech and life sciences have been at the forefront in 2012 and 2013. So maybe we'll skip to some of the specific provisions and who's using what there, and maybe I'll turn to Michael.
Thanks, Anna. So maybe what we'll do. Do you want to go back to this
Sure.
for just 1 second?
Absolutely.
Yeah. Thanks. So one thing, we had mentioned before that an emerging growth company is one with a total annual revenues of less than $1 billion. The SEC needs to look at that provision every 5 years and decide whether or not to adjust that provision upward. And the other thing to keep in mind, which doesn't have much application anymore, but an issuer, but there are some situations where this still arises, particularly where somebody's been through some sort of reorganization or restructuring, is in order to qualify as an emerging growth company, the company first has to have sold its common stock in a registered offering on or after December 9th of 2011. So I think that there are a number of accommodations that emerging growth companies that were made for emerging growth companies in the SEC. And this slide lays out many of those provisions. They can provide 2 years of audited financials and selected financial data rather than 3. They don't need a CD&A. They are able to provide registration statements on a confidential basis with the SEC before it needs to. You need to get public and sort of expose yourself to the world at large and go through that while in the public forum. I think we can all think of IPOs that have happened in the past where they were publicly filed and going through the SEC comment process and seeing the disclosures that get made and things that the SEC focused on. Now, although the comment letters and the drafts wind up getting public at some point in time, it's all done confidentially, and companies are able to take care of all of that before they're sort of subject to scrutiny of the whole world while they're dealing with the SEC. Another accommodation was the ability to test the waters before and after filing a registration statement by engaging in oral or written communications with qualified institutional buyers and institutional credit ones. They have an ability to opt out of new financial standards that are adopted. They have the ability to transition to 5 years for pretty much all of the reporting, but also the auditor attestation requirements. And there also is the ability of a broker-dealer to publish research reports about a company currently in registration, even as participating in the offering. The view was that the existing rules that were on place limited this activity, and that was sort of hindering the ability of smaller and newer companies to be able to raise capital. So, should we talk about
which of these provisions have been
Yeah.
the most important or most popular with the issuers?
So I think that if you were to just talk to the issuers and leave out the other advisors or the investment banks, I would say they were all very popular with them. But being popular with the issuers and what's been most used are probably two slightly different questions. I think that what you're seeing as far as the most used provision by far is the ability to confidentially file registration statements and get ready to go public outside of the eye and the scrutiny of the markets, reporters, everyone else. What this has done, and Anna mentioned in her remarks that we are seeing an uptick in IPOs, but maybe not as much as what people wanted. But because these are all submitted confidentially, nobody has really a good idea as to what's in the pipeline. Which, if you talk to investment bankers, they don't like because it provides uncertainty, because they can now have more difficulty advising their clients as to what's in the pipeline, sort of working on timing, when's a good time to go, when's a bad time to go, what's out there from a competitor standpoint. We need to get in here quick, we need to get in here late, whatever. I mean, they don't have that sort of market check that they used to be able to have. But this is by far the most used provision. Probably another one of the most used provisions is the ability to reduce the compensation disclosure to not provide CD&A. I find this one sort of interesting. I think people don't think that full-blown compensation disclosure, a CD&A, is now all that necessary to be able to sell their securities in the IPO, which sort of goes against everything the SEC has been doing in trying to build up the compensation disclosures in CD&A. But this, again, is another provision, and I think in most situations, if you talk to the advisors, the investment banks, they all say it doesn't really matter. I think one of those reasons is I might be being a little bit glib, but the practices from before, the compensation practices from before you were public versus after, what they are at the time you go public and later, they may change. And so therefore, kind of a detailed discussion of what decisions were made and why from before you're going public just really isn't all that relevant. I think those are probably the two most popular provisions.
I would agree with that. We now spend an awful lot of time talking with issuers as well as with investment banks about some of the other provisions, specifically relying on the EGC accommodations and providing reduced financial information. So as we were talking about, an emerging growth company can elect to present 2 years. However, what we're seeing there is that at first, investment banks specifically were very reluctant to encourage companies to rely on the accommodation, and we're encouraging companies to provide financial information for a longer period of time. And the argument that we heard most frequently raised by bankers is that institutional investors really wanted to see a company's track record over a longer period of time, and would have been asking for that longer financial presentation in meetings. So if you're asking for it in meetings, or if people expect that it's going to be presented in the context of a roadshow, then you really need to include it in the IPO registration statement. Now, that may be softening a little bit as market practice evolves and as we all get a little bit more comfortable with the Jobs Act. If you look and test at different periods of time, what you see is that in more recent IPOs, there has been a little bit of an indication, and I say a little bit because it really also is very dependent on the type of company. There's been a little softening in that, and we are seeing a few companies that are coming with only the 2 years. And that tends to be companies where perhaps financial results may not be all that significant. And what I mean by that is in the context, for example, of a biotech company. where they principally have losses. Having that longer financial period may not be, quite as revealing or quite as telling, as opposed to a company that does have revenues, a consumer products company, let's say, where it's important to see those trends over a longer period of time. The other aspect where we're seeing a little bit of variability is on EGCs tending to defer their adoption of of generally accepted, newly promulgated, generally accepted accounting principles. There again, you sort of see some variance in practice. Some companies are choosing to delay that, but not enough where we can sort of make a statement across the board about acceptance on that. So really, confidential filings and executive comp are where we really see a big difference, I would say.
And on that last point on the ability to defer compliance with new financial standards, I think initially when this provision came out, everybody was leaning towards saying they were going to opt in and comply with everything. And now as this has been going on for a little over a year, I think you're seeing more discussion and sort of thoughtful consideration in deciding what they're going to do as opposed to sort of automatically opting in.
I think that's right. The other area where we're seeing some developing practice is test the waters. So as Michael was saying, an emerging growth company can go out and before its IPO, before it's submitted confidentially its registration statement, before or even while it's undergoing this confidential submission process, it can go out and approach qualified institutional buyers or institutional accredited investors and talk to them about the offering, the company, its business plan, and so on. Almost instinctively, issuers thought that this was a great new opportunity for them, and they were going to have a lot more flexibility. We work with a lot of foreign private issuers, and they have always been able to do this in Europe and in Asia. And so being able to do this in the United States was a very welcome change. They thought it was really archaic that the SEC had all these artificial prohibitions on gun jumping and communications before an IPO. In practice, what we're seeing is that bankers most often are telling companies that institutional investors don't want to be bothered or contacted too early in the process. They want to be contacted when things have really come together, when the issuer has been through a few rounds with the SEC and the disclosure has more or less settled, when the issuer is closer to officially launching its roadshow. So it hasn't worked out in quite the way that Congress necessarily intended, because this test the waters provision was supposed to save issuers money. It was supposed to essentially permit an issuer to go and see if there was a market, an appetite for its securities before it spent all of the time and effort and money associated with a full-blown IPO process. What we are seeing is that in a couple of sectors, again, like biotech, where it's very specialized and where there's a need, for example, to engage with professional institutional investors familiar in that sector with the company's patent portfolio, its technologies, and that requires an investment of time on the investor's part. These test the waters conversations are happening, so maybe that's a glimmer of hope that over time it'll be a more accepted practice.
Yeah, I think, and just sort of hitting on that last point, I think what you're seeing also are just sort of some conversations, not, as Anna pointed out, investors, as for the most part, were saying, we don't really have the time, you need to be further along in your process, have a document or whatever. But I think you are seeing some investors willing to sort of talk about a very initial phase about whether somebody's got an idea, is that something that might be worth exploring and going public? Unfortunately, that's at the stage where it may not be an offer in the first place and may not need this provision to take advantage of. And so it doesn't really save the companies much money in trying to decide whether or not to start going down the road before they can really get some good feedback from the investor.
So before switching gears and talking about private offerings and accredited crowdfunding, one last note. So as Michael said, another benefit or accommodation for emerging growth companies is that Congress relaxed a lot of the prohibitions on research coverage, a lot of the quiet periods around research in proximity to an offering. So in theory, under the Jobs Act, an investment bank, even one that's participating in the IPO, could provide pre-deal research on the company before the IPO is completed. And it also could immediately, once the offering's been consummated, can come out with research. And the Jobs Act requires that no SRO, so namely FINRA, or the SEC impose any arbitrary prohibition on research. So FINRA amended its rules to coordinate and harmonize with the Jobs Act, and here, unfortunately, we still have the legacy of the IPO research settlement, which prevents a handful of the largest investment banks from really taking advantage of these rules. And what that's done is that it has sort of forced the market to migrate to what these firms can do. And so now what has happened is that there's this informal 25-day instead of 40 days, so granted we've made some improvement, 25-day lag between completion of an IPO and when an investment bank actually commences and publishes research on the emerging growth company. We really haven't seen any take-up of pre-deal research. So investment banks, having been traumatized by research settlements, by the prospect of litigation and regulatory actions, have been really very reluctant to write research on a company before it's going public. So not clear that that'll change anytime soon unless perhaps we have different rules relating to liability or clarity relating to liability for research.
I think it's really interesting that Congress decided to prohibit the SEC or FINRA from adopting or maintaining rules that prohibited this, but didn't also address the IPO research settlement thing, which is really what's one of the big. Obviously, the other rules were there and prohibiting, but the IPO settlement was a well-known thing that was going on that was going to limit these companies from participating anyway.
I agree. So I think that we'll continue to see companies test the boundaries of different Jobs Act provisions of Title I. We might see some smaller, more specialized broker-dealers publish research earlier before that 25-day period, or even come out with pre-deal research. But I would say that in the context of IPOs, the Jobs Act is probably a starting point, and we would need to look for additional changes to really restore an IPO market for smaller companies.
Before turning to Title II of the Jobs Act, at Lexis Practice Advisor, we're very focused on providing practical guidance to lawyers. So I wanted to get your perspective on how Title I has impacted the lawyer's work and role in the IPO process.
Sure. Why don't I'll start, Ron. You could sit here and look at it on one level. It may not really provide a lot of impact at all, because you still are preparing the disclosure document. You're still looking at competitors' disclosures. You're still providing advice on the things that you used to provide. I think where it is doing now are, as Anna was pointing out and as was highlighted on the slides, there's now a greater discussion about all of the things that the Jobs Act provides and whether it's a good thing or a bad thing, and involving various of the advisors in that decision-making process. So there is time spent just looking at these Jobs Act provisions because issuers, I think, generally across the board would want to try to take advantage of every one of them. And it requires a discussion to try to go through. And as Anna had on some of the slides, highlighting percentages of people taking advantage of provisions or taking advantage of things generally. One of the interesting things in the Jobs Act was that it prohibited the SEC from disclosing anything that had been confidentially submitted. So nobody actually, unless you're working on the filing or you hear about the filing, that's something that's been submitted confidentially, you don't actually know what's there or what the practices are that are there or how the SEC's process is evolving with regard to ongoing processing of registration statements. So we only can look at things once they're actually filed, which is 21 days before they want to begin a roadshow. And so one of the ways practice is changing is very constantly monitoring what winds up showing up getting getting publicly filed, so that we can take a look at that and decide how that might impact the draft of a document that we're currently working on, because it will reflect sort of the current SEC thinking on, what you might have to be disclosing on the cover, or where market practice might be going generally with regard to what investment banks are advising and things like that might be advisors other than your own working with your own clients.
Yeah, I think we tend to have more discussions on the same topic about when to flip from confidential filing to public. A lot of those discussions are very strategic. For example, if the company is also contemplating doing an M&A transaction, it's a dual track, maybe an IPO, maybe a sale, or if the company is going to disclose, again, for business reasons, whether by tweet or otherwise, that it's actually confidentially filed with the SEC. So we talk about that a great deal. We also talk about the timing of commencing the roadshow. Again, some investment banks only feel comfortable engaging in test the waters communications or these preliminary meetings when the registration statement has been publicly filed for the first time. So we spend an awful lot of time talking about all of those various sort of tactics and strategies.
Okay, great, thank you. Let's turn to Title II of the Jobs Act, and we'll open it up to the entire panel as the provisions relate to the relaxation on the prohibition against general solicitation, general advertising. So I'll start by asking, how has the ability to generally solicit changed the private placement process?
Can you start? Yeah. As Mike said, the rule went into effect on Monday. So what we're seeing, at least in the startup space, is there are various platforms out there that are not broker-dealer platforms, like AngelList or CircleUp, that actually allow startups to meet angel investors. Then they basically go off the platform and they, do all the transaction and closing without the platform being involved. So they're not a broker-dealer, they can't take a commission, but they're very effective at finding angel investors, helping them find startup companies. I know that as of the end of the day Monday, I think the number is something like 1,470 of these angel companies, startup companies listed on AngelList, had moved their kind of offering page outside of the accreditation wall. So that's sort of just the first day. We also saw a lot of movement by funds, different kinds of funds, private investment funds for the most part, out there talking about the fact that they're raising capital. So I think it's really baby steps. Obviously, we're only in day 3. So far, there's been no fraud, which is great because that's what the regulators are very worried about, and that's what sort of led to the proposed Reg D changes that Mike talked about a little bit in his opening remarks. But I honestly think this was the entire intent of Title II of the Jobs Act, was to let companies go out and broadly solicit for accredited investors. And I think that's the most important point. The rules haven't changed around who can buy the securities under Reg D. You have to be an accredited investor to buy. You have to go through an accreditation, questionnaire, and then also the implication of generally soliciting is that all of the potential buyers have to be verified as accredited. So either the issuer or third party, we'll talk about that I think a little bit later, have to actually get copies of people's W-2s, 1099s, brokerage accounts, and actually verify that they actually are an accredited investor. So that's a big change in the market. And I think what we'll see is lots of general solicitation, but if the buyers aren't going to step up and provide the documents to verify, then companies will most likely stop generally soliciting and stay with the current model, which allows them to, do 506B offerings without general solicitation, but not have to verify accreditation. So it's a pretty exciting week, but too early to make a real assessment, except the companies are really excited.
Yeah, and Marie, you mentioned accredited investor crowdfunding, and I think it's really important just to clarify. As Mike said in the opening remarks, we have no rules under Title III for crowdfunding. But accredited crowdfunding, which people call crowdfunding, and doesn't happen under Title III, is really turning out to be incredibly important in terms of how people are financing.
Correct.
And taking, not necessarily minimizing the role of a broker-dealer, but showing that there's an alternative.
Yeah, and it's been a big change for the sort of standard VC structure that most startups relied on for many years. I mean, previously to sort of AngelList or these other types of platforms, you really had to, be a high-tech Silicon Valley firm, or maybe you were in New York or Boston to really get access to a large pool of capital. And the implication would be that the venture capital would take a big chunk of your equity in order to make the investment. This really changes that model on its head, especially when considered in conjunction with the change from the 500 shareholder threshold for registration to the 2,000. So now startups have a much broader ability to raise capital. If they're willing to allow individuals to buy stock, accredited investor individuals, they're going to do that. So I think that's the other thing. It'll be interesting to see whether startups really want individual accredited investors buying their stock or whether they prefer to stay with institutions over time. I think early-stage startups, and I know we're going to talk about this a little bit, I think early-stage startups are going to be more willing to take money from individual accredited investors, but later-stage companies are probably going to want to stick to institutions because handling all those shareholders is a lot of work for the company.
And I think to that point, we talk about this word general solicitation, but it's a very broad definition. And I think this week we're just seeing who's dipping their toe in and in what way. So this doesn't mean that they're necessarily putting an ad on the television or in a newspaper. It can be something as simple as mentioning it to a group of people like we're having today at a conference that can constitute by the definition of general solicitation.
I noticed yesterday that somebody that I'm connected to on LinkedIn was generally soliciting an offering of an AngelList company. Like literally in my LinkedIn newsfeed, there's this guy going, hey, check out, I don't remember the name of the company, they're raising capital on AngelList. And my heart stopped, and then I thought, oh, okay, it's okay. But it's, from a securities lawyer point of view, it's scary, but it's legal.
I think the other thing to sort of keep in mind is that, and we sort of focusing on startups and angel investors, but what Jobs Act didn't do was actually change the old 506 provision. So if you don't want to generally solicit, you don't actually have to change your practices. And so, for startups, and particularly in certain industries, there may be reasons why you want to change your practice, why you might want to generally solicit, which may not necessarily relate to the raising of capital, but it might be, getting your name out there and the fact that you're doing something. But you have some of the other issuers may not be jumping in quite as fast. It might be you might have funds as clients or private investment companies who are going to the point. I think Karen, you were the one who just made this, or maybe it was Anne Marie, where they don't necessarily want to have to put up with some of the smaller investors who might only be investing smaller amounts. So really it's leading to discussions about whether to change their practices or not to change their practices. And they may be a little bit slower in moving into this process. It will be a very intentional decision for some people to move into this as opposed to in certain areas than others.
But I sort of have this vision in my head of, however long, a month, 2 months, you'll have potentially groups of CEOs on CNBC or Bloomberg or whatever, and they're being asked by, Carl or whomever, what's going on with your company? Are you raising capital? And 3 people say, we're absolutely raising capital, da-da-da, and the 4th or 5th person says, I can't discuss that right now. So my CEO is not going to be I'm not discussing this person. My CEO is going to say, we're talking about it. And we'll say, okay, fine. But, I think that the more it becomes where companies are headed, they may generally solicit, but they may not want to accept individual investors, but they're going to cover their bases just in case. So it's going to be an interesting.
And I think that's one of the things, though, that this Title II, the general ability to generally solicit, did not get really well addressed by the SEC. Was, Anne Marie was mentioning sort of the intentional CEO not wanting to be quiet, wanting to say stuff. But I think one of the things the practitioners in this area have long faced is sort of the more inadvertent disclosure, the inadvertent statement at a conference, or things like that, and whether or not that constitutes a general solicitation, what that does to the ability to deliver opinions, or things like that. In what the SEC's rules did was not well address that situation, the unplanned for general solicitation, as opposed, it really addresses well the planned for general solicitation.
Yeah, I think that the accidental statement that then constitutes a general solicitation. But I think, to Anne Marie's point, if enough people in your space, as a fund or a company, are generally soliciting, there may be this pressure on you to follow suit just to be at norm, and the new norm is that they're doing that. So that's something that may come under consideration. And then again, it's the question of what type of general solicitation you're doing. Is it that you have a list of targets and you wouldn't have ordinarily sent something to them, but now you will? But it's a really confined group of people, but by the definition of general solicitation is a solicitation nonetheless.
Right, because previously you could only reach out to people you had a pre-existing relationship with, or that the broker that you're using as a placement agent had a pre-existing relationship with. So you're exactly right. You may have an idea of people that you want to touch or reach out to, or institutions that you don't have a relationship with, and that would have constituted a general solicitation. That's a really good point.
So maybe it's worth taking a minute and just going through the SEC rule. And so, as we were all talking about, what the SEC final rule does is create this bifurcated universe. So you can still do a private placement under Rule 506B where you're not using general solicitation. And with that 506B offering, you also can rely on the traditional statutory private placement exemption, Section 4A2. So the SEC's rule and the Jobs Act doesn't change the statutory private placement regime. 4A2, if you're doing an offering, traditional private placement, just relying on the statutory exemption, you can't generally solicit. If you do a 506B offering, you're not going to be using general solicitation. So the new rule, 506C, permits general solicitation provided that certain conditions are met. That the issuer is going to take reasonable steps to verify that the purchasers are accredited, that the purchasers are indeed accredited either because they fit within one of the categories or the issuer reasonably believes at the time the securities are sold that they're accredited, and that all the conditions of for use of Reg D are satisfied. So a lot of ambiguity remains for, as Mike was saying, the inadvertent communication. If you didn't intend for your offering to be a 506C, which suggests that you have to take these additional verification steps, you really were planning on doing a 506B, but the CEO or someone else made an inadvertent statement. Does that bump you into this new world of 506C? And then, if you're in 506C land, what are reasonable steps to verify that your investors are accredited? So the SEC has these sort of principles-based provisions. You have to apply common sense and think that what's reasonable is going to vary depending on the circumstances. So you have to think about the purchaser. If a purchaser is an institution, well, then it stands to reason that your additional steps to verify needn't be as intrusive as if the purchaser is an individual. Likewise, if you already have information about the purchaser. So if you're a company that's using a broker-dealer, the broker-dealer is going to its existing customer base, and those are known customers of the broker-dealer, well, then perhaps no additional steps need be taken because there is that pre-existing substantive relationship. The broker-dealer knows their customer, has loads of information about that customer, and it also depends on the nature of the offering. So if it's an offering that's conducted with a broker-dealer, probably fewer steps. Whereas if it's an offering of the type that Anne Marie was talking about, using one of these internet-based platforms, you're reaching far and wide to attract investors who you have no prior relationship with. Additional steps there would be more intrusive. So the final rule does address a lot of the concerns that commenters had in terms of providing a roadmap for the steps that would constitute reasonable efforts in terms of verifying accreditation. And I'm going to turn it over to Karen and Anne Marie to talk about the steps that the SEC outlined and how somebody goes about verifying status.
So the SEC in the final rules, I think very, very smartly, as Anna said, there's a principle-based approach, but there's also a non-exclusive list of steps that will be deemed to be reasonable steps to verify, which I think was really important because the proposed rules only provided a range of potential actions without actually building them into the rules as a, not a safe harbor per se, but as a, definitive way that you can satisfy the rule. So the final rules provide 4 non-exclusive options. An issuer itself can either verify net income by reviewing potential investors' W-2s, 1099s, K-1s. I always forget the last one, Karen. You always remember it. W-2s, and a tax form, your cover of your tax filing. But they'd have to actually require that the potential investor provide all this documentation, review it, obviously manually at this point, and then make a determination that that person actually satisfied the threshold, which is $200,000 a year in the last 2 fiscal years, and a reasonable expectation of making the same in the current year. The other part of the net income test is if you're making $300,000 jointly with your spouse, you can also qualify, but the rules require that you then also look at the spouse's documentation and require that you and your spouse, if it's joint, or you by yourself, if it's you as an individual, have to give a representation that you have this expectation of making that money, at least $200,000 in the current fiscal year. The other option is under net worth. The way that the SEC built out the net worth test, which I think is a harder test to get really comfortable around because it's really much easier to flub on net worth than on net income, is that they'll accept brokerage statements, bank accounts, certificates of deposit, tax assessments. You have to back your primary residence out of your net worth calculation, but if you have investment property, they will they'll allow you to contemplate the tax assessment of that property by the local tax assessor, and also independent third-party valuation. So if you have a fine art collection or jewelry, or I would like to have an expensive fine wine collection, which I don't have, but that would be another asset that you might be able to calculate. So those are the sort of things that you are allowed to look to when you verify net worth on assets. On liabilities, you have to upload a copy of your credit report from a national credit agency. And then you do the calculation of, are your total assets at least $1 million or more once you back out the liabilities. So I think that test is more difficult. I would certainly have a little concern if, and this is my own view, so I would have a little concern if somebody's proving net worth just by independent third-party appraisals. That sort of would make me nervous, but that's what the SEC's final rules are. Then you have to give a representation that all of the liabilities that you've disclosed you've disclosed all the liabilities necessary to determine net worth. So that's the representation. And again, same joint with your spouse. If you're getting to the $1 million joint with spouse, same sort of procedure for net income, where you look at the spouse's documentation and get the representation from them as well. The third non-exclusive option, which I think more issuers probably go to, is to outsource or not outsource, engage a third party to do the verification on your behalf. And the parties that the SEC's non-exclusive list allows are basically registered entities. So broker-dealers, registered investment advisors, lawyers in good standing. That might take Michael off the potential list, but I don't want to get into that. And CPAs in good standing. So a company can engage one of these 4 types of entities to do the verification on their behalf. Two kind of interesting things one thing on net worth I forgot to mention is that all the documents that you upload or you provide to show net worth have to be no more than 3 months old. So this is really a point of transaction analysis. So if you actually engage a third party, the third party has to be able to tell the issuer that they've done the verification within the last 3 months. So there's sort of 2 3-month requirements. Net worth documents have to be no more than 3 months old. And if you engage a third party, like a broker-dealer, they have to have done the verification, either net income or net worth, during the last 3 months. So that makes the process really tricky. So if you're an individual who wants to make multiple investments in multiple companies over the course of the year, you may have to go through verification multiple times. And on the net income side, at least, I think, refresh your representation that your income, that you have a reasonable expectation of earning the same amount of money in the current fiscal year if you're using the same source to verify you. So that it becomes a little tricky. The 4th option is that if you are a shareholder who's already purchased securities under Rule 506, the company can sell to you again without actually verifying. If you are an accredited investor who purchased securities in a 506 offering in the past, the company can sell you additional securities under 506 without making you go through verification. So we're much happier that there's a non-exclusive list, but it's not necessarily the easiest thing for investors to get comfortable with. I think a lot of people are not going to be willing to provide their personal information to startups or other investment issuers that they don't really know except they want to buy their stock. I think companies will be much more likely to want to engage a broker-dealer or a third party. And Karen will talk about the second markets offering this sort of product ourselves. Sorry, go ahead.
You're doing the 506B. Are you still allowed to rely just on the certification?
Yes.
Yeah.
That's the upside of not general soliciting, is that you don't have to verify.
Right. So it's more of an attestation.
But if you verify, that questionnaire is no longer deemed sufficient.
Karen, maybe before you go on, one thing, can we go back to the 3rd option there, the written confirmation? I mean, obviously, I haven't had conversations yet with investment advisors or broker-dealers, but it has come up in the firm about whether lawyers would be willing to provide, and I don't mean to steal any thunder, but whether lawyers would be willing to provide this sort of certification. And, I'm not aware, I'm sure somebody probably somewhere has been asked, but I'm not aware of any lawyers who've really sort of are willing to sort of step up to the plate and certify as to some person's net worth or net income. So it's going to be interesting to see with the other people who specifically were identified by the SEC, whether any of them are willing to do it. I mean, obviously, an investment advisor to an individual might have a lot of information about that individual's asset or net worth, but there will be additional steps that will need to be taken in order to be able to provide a verification, and plus just they may be wondering what their liability is for providing the verification in the first place, and that really wasn't addressed in the SEC's rules. So, I mean, I think there's some interesting questions here, and it'll be an interesting to see how this develops, if it develops at all.
Yeah, as you heard in the opening, my responsibility for Second Market is to work with the law firms and their clients with regards to Second Market service offering. So I have had the conversation with a number of law firms and have yet to have any that have suggested that in any meaningful way that they plan on participating on the verification component of general solicitation. So they're happy to meet me.
Yeah, one firm, I think it was K&L Gates was suggesting that they thought it would cost a law firm billable time about $100,000 per offering to do the verification themselves. And I'm not sure how many investors that contemplates, but that's a lot of money, and especially for a startup, which they don't have a ton of cash. So I think the options may be startups could hire a broker-dealer like Second Market to do the verification on their behalf, and maybe they charge the investor. Like, there's going to be different ways that this ends up playing out. And I think if you're willing to invest as an individual, you're going to want to give your documents to somebody who's regulated, who's subject to confidentiality, like a broker-dealer's, subject to Reg SP, FINRA regulated, SEC regulated. FINRA comes in and checks processes on an annual basis. So I think that that's where the comfort level will end up in the marketplace. But again, we'll see where that ends up.
Yeah. I mean, from my perspective here, and Anne-Marie is alluding to one side of it, from the investor side, I don't anticipate that somebody, and think about it, an investor, an accredited investor who is making multiple investments in different companies or funds does not want to be disclosing information, personal information about themselves directly to the issuer upon which they're investing. They do not, it's almost like, I don't need them to know that information. So having a third party in the middle, I think, is a very valuable thing to getting general solicitation actually to work for all parties. On the flip side, as the issuer, if you think about it, you've got enough on your plate just to run your business. And now you want to do this to get your business even more robust, but the requirements of accreditation verification are quite detailed. As you heard, you'd have to go through all of that information provided by those individuals. And depending how broad you go out for your general solicitation, this could be a full-time job of somebody at your firm to just look through, the net income statements, the financial statements, and what makes them so qualified to do that. Second Market is a broker-dealer. We have been in this space in terms of private placements and working with companies and funds for quite some time. So this was something that we, even our CEO was incredibly involved with the Jobs Act on both the increasing the number of shareholders you could have before you registered with the SEC, but also on the part of general solicitation, because we think it's real added value. And so being so much in the heart of it, we really wanted to be able to also help when this came out. So, and I can't say this was just me, it was a group of us here at Second Market that have spent the last year, as soon as we knew the rules were out, even though we didn't know the final rulings like we did this summer, talking to law firms like yourselves and really understanding what do we think that's going to look like. How do we build something that is going to be useful for the issuers? And we have a product called Checkout that we've been using, to your point, for 506B, where we've been helping companies who are raising capital or funds go through an electronic platform that really is almost like a TurboTax for the investor, so that they have an easy way of indicating that they want to be an investor, filling out the information, using the legal documents from the law firms, and going into the closing process, including as a broker-dealer serving as escrow if necessary. So what we've done now that, starting Monday, is we've added another component to that where we will do that accreditation verification. So we understand the safe harbor on two fronts. One is, what is the requirements that they're indicating we need? So how do I verify net income? All the list that Anne-Marie just gave you, the W-2, et cetera. And then if we go to the net worth side, what do we need to get from them? We have an account management team that is staffed up to review this information and to make that determination on behalf of the issuer, and then provide the issuer at the end of the day with all the completed documents related to that fundraise, including the information about the verification process that we went through and the information that was provided to us. But again, back to that first conversation I had, we're not giving the exact net income tax return to the issuer, but rather giving them comfort that we've reviewed that particular document for their investor.
And I think for the lawyer advising issuers, I think that's the conversation you have to advise the issuer to have with whatever third-party service, if they're going to use a third-party service, is to have that conversation to dig down as to what the processes are that they do. Is it to determine whether it's reasonable to rely on that third party? We have one client where, and there are various processes that are percolating out there that might be used. We have one client that was talking to somebody where what they want to provide accredited investor verification, but they don't actually want to use any actual information from that investor. What they want to do is data mine the internet and gather whatever they can from over the internet and then make a recommendation whether or not the person's accredited. The lawyers, so basically what it does is it leads to a discussion about whether or not that's something reasonable to rely on. in trying to decide whether the issuer will have taken reasonable steps to verify investor status. So I think what it leads to is the lawyer's role in this is to advise their client to have those conversations, to understand what that third party is doing so that you can have a reasonable basis.
I think the scary implication of doing it wrong is that 506 is not available to you, and now you're basically a 4-2 offering, and you're subject to state discussion about how your offering was done. And one of the reasons I was very glad to see them put out the non-exclusive list of actions that companies could take to verify was that prior to that, under the proposed rules, the state regulators have been saying, this is going to be very difficult because each state's courts will have to determine whether reasonable steps were taken. And if they were not, in the state's view, you could have 50 states saying that reasonable steps were something completely different. And it will be a state enforcement issue if your 506 is blown because you didn't verify properly. So there really is a very significant downside of doing verification the wrong way.
And the states are gearing up for monitoring.
They're definitely gearing up.
I'm sorry, we're just about out of time, so I'd like to give the panelists an opportunity to make any closing remarks regarding the Jobs Act and anything we've discussed this morning.
I'll start. So in addition to all of the verification process, I think for lawyers it's an interesting time to be advising clients. Clearly, this is a really significant change, being able to use general solicitation and general advertising. It may not be for everybody. And so I think that we'll see the market sort of segment itself. And there are many more considerations for issuers that we haven't had a chance to go through. But for example, if an issuer does choose to use general solicitation, they have to think carefully about which medium they're going to be using, who's speaking on their behalf, liability for their public statements. Just like existing public companies have Reg FD or communications policies, even a private company is going to have to think carefully about who's authorized to speak on their behalf. And then there are a lot of sort of special issuers who are subject to a whole series of other rules. We alluded to private funds. So a lot of private funds that are advised by a registered investment advisor or advised by an entity that's a commodity trading advisor are subject to an existing rubric, which this doesn't really touch or affect, that relates to how they can communicate, how they can advertise, the content of the advertising. Similarly, for broker-dealers, if you're an issuer that's using general solicitation that's involving a broker-dealer, the broker-dealer has responsibilities that have been in place for quite a long time about its communications, the content of its communications under FINRA rules. A broker-dealer is required to file with FINRA all retail communications. So any general solicitation that's used in a transaction where a broker-dealer is intermediating is ostensibly subject to the FINRA filing rules under Rule 2210, or for private placements, 5123. So there are a host of other issues that are related depending on the types of entities that are involved in the offering, the role that they're playing. And then at the same time, we didn't talk about bad actor rules, but most issuers are grappling with general solicitation coming into play, as well as bad actor rules also having taken effect on Monday. We didn't really get a chance to talk about these, but these also impose a responsibility on the issuer and a broker-dealer, if they're acting in a private placement, to make sure that they've done all their homework, they've taken steps to verify that no one that's involved in the offering is a bad actor.
I think, my view is that, it's a very exciting time in the planet of private placements. I'm very glad that the rules are finally effective. I think, as with anything new, it'll take some time for the securities bar and regulators to determine, what best practices are. But I think that people are really being very focused on it right away and trying to figure out what's going to make people comfortable enough to issue legal opinions. And that's, I think, always the best place to start. So we'll see.
I think from my perspective, it is absolutely exciting that that this is available to them. But the devil's always in the detail of how you do the process, and so there is that contemplation of how much I'm going to generally solicit, and if I do generally solicit, what am I going to do in terms of on the back end, deal with all these individuals or institutions that are now opportunities for me? How do I get them through my pipeline? Whether it's third party or if I decide to take this on myself.
Maybe three things to a couple of practice points. One is on general solicitation. All the SEC has done so far is come out with its adopting release. They really haven't provided any interpretations. It hasn't, based on past practice, it's been fairly common for them shortly upon effectiveness of a rule, either right before or right after, for them to issue some interpretations and post them on their website. So I think we all should be monitoring the SEC's website to see if they post some interpretations that might help with some of these questions. For example, the inadvertent general solicitation, maybe that's something they can do interpretively or not, or things like that. So I would expect that we may see some interpretations. There's been some rumors going around that we will see some, but we don't know what they'll be. I want to go back to something Anna mentioned in her remarks and sort of reiterate the importance of that. What the SEC did with general solicitation applies only to the SEC. It went through where there might be some conflict with its other rules, whether it's the Investment Company Act, and issuers who rely on exemptions from the Investment Company Act who can't be doing public offerings, and whether or not a general solicitation is a public offering. Or it went through its rules of Regulation S, where there is a prohibition on directed selling efforts in the U.S. and made clear that, again, those rules, there are the things that won't apply. But where the SEC couldn't provide comfort, they didn't. So if you're if you're working with an issuer that's doing an offering offshore, just because you can do a general solicitation here in the States doesn't necessarily mean that pursuant to the other countries that you're doing an offering in, that the general solicitation here in the States might not query your ability to do it in whatever country you're in. So you need to be very much aware of what the requirements are in whatever countries you're doing an offering and whether a general solicitation here might impact that. Anna also mentioned people who might be subject to the Commodity Exchange Act. The CFTC has, in response to some Dodd-Frank stuff, adopted rules, commodity pool operator rules, which people got a wide swath of people up in arms. They created an exemption for people having to do this. They have to do certain filings. But one of the things of the exemption is, again, that you don't do a public offering. They have not clarified whether they will interpret that meaning the same way the SEC does. And so if you have if you're representing or working with an issuer that also it may be subject to the commodity pool operator rules, you have to worry about the CFTC's interpretation. And maybe the last thing from my perspective is the bad actor rules. And you think about these as people who are officers or directors of the issuer or things like that. But the rules actually apply to, go to that next one, I think.
There we go.
This one. There are people on the list of the slide that Anna just put up that you might not necessarily think these bad actor rules apply to, including 20% stockholders. So if you're representing a startup company or you're representing a fund or a private investment company or something, many of them may have more than a 20% stockholder. You have to go to these people and find out whether they have any bad actors in trying to decide whether you have any bad actors and can rely on Rule 506. And similarly,
I just want to make sure that's something that I think some people are not focusing on. The bad actor rules apply to every 506 offering, not just the new general solicitation 506C. It also applies to 506B. So it implicates every 506 offering that's occurring after Monday.
And I think maybe just the other thing to keep is also people who are the issuer is using as soliciting agents, whatever you want to call them. This also applies to them. So, I mean, the bad actor, I think if you're working with somebody in a private placement relying on 506, you really should be paying attention to the bad actor rules and who it actually covers. And it's broader than who you might otherwise think that it applies to.
Well, I'd like to thank our panelists for their valuable insight this morning. It'll be interesting to see whether the Jobs Act evolves and plays out in the way that it has so far, and to see whether some of the trends continue. I'll now like to turn the program back over to Kevin Elphick, who will give some closing remarks.
Yeah, everybody, thanks. I really appreciate it. Just a couple of housekeeping. Again, please make sure that you're filling out your forms so that you can get your credit. We also have in the back some snacks, some networking opportunities. Maybe if you didn't get to ask some questions of the panel, please stick around. Also, in each one of your folios, there is an ID for you to go ahead or when you're back at your office to sign in and take a look at Lexis Practice Advisor and our Securities and Capital Markets and see some discussion on some of the topics that we just heard about. I always like to try to look for a silver lining in everything. And so what I like to think about, what we heard from the panel and from the keynote address is that the one good thing, right, is that the SEC is actually looking at past practices and knowing that things like technology and the internet, have actually changed things. So they're making some inroads and trying to help deal with that situation and make it a little bit easier, perhaps, for some people to raise capital. And at the same time, I think that what we're saying is that, it's still up in the air. There's a lot to be done and said. Lots of good, I thought, very practical information. Even if we didn't have the answers today, lots of really good things for people to think about as you go back and talk to your clients or people that you're doing business with who are attempting to take advantage of anything with the Jobs Act. So again, I learned a lot, and so I appreciate the panel spending the time to prepare and thank them very much for their hard work. And thank you all for attending, and please stick around and we can have some more talks. Thanks a lot. Thank you so much.